Please state your name for the record if you're going to speak, and try to contain your remarks to 5 minutes.
Thank you, Senate President, for allowing more public comments. I thought there were more. Apologize for any delays. Buenos dias, Tito, and good morning, honorable senators and the viewing public. I am Leila Staffler, and I am here to give my comments this morning as a sitting member of the House and a former member of the Special Investigating Committee on Impeachment. I'd like to tell you a little bit about the Special Investigating Committee on Impeachment. It lasted all of 40 minutes and 48 seconds, as you know, because I'm sure you watched the video. Of that, 13 minutes were public comments. Recess totaled 20 minutes if you counted them all up together. When we came back from recess, there was no discussion. After I made the motion, Rep. Tina gave some context to the action taken that day in the committee, and that consisted of Democrats, Republicans, and independents. We had come to a consensus to send the articles of impeachment to a full body vote from the House. Then the members of the Special Investigating Committee on Impeachment voted unanimously to send the vote of impeachment to the full body of the House. They didn't have the will to stand up for the indefensible abuse of public funds. Instead, they voted yes, send this vote to the full body of the House. Now, while it is true that during the session where we did vote on the articles of impeachment as a full body of the House, Rep. San Nicolas did raise questions. And I ask, why didn't he raise those during the special impeachment session? Why did he not bring those objections up during the special impeachment investigation? Why was he so quiet? Because possibly he didn't want to defend the indefensible. Now, to be clear, I still question Rule 19. The plain language, not the interpretation in the rules of the Senate, make this dismissal time barred. Now, I'd like to address a few things that came from the last session. Senator Cruz, you did say that you wished that we were here, but we declined to appear. And yes, it is true that we declined to appear, but not because we are not confident. We declined to appear as a singular unit and respectfully asked more than once that we present these articles of impeachment as a team. We want the same advantage that our governor has, representation of a team, and not chosen by a single person, not chosen by the Senate. Maybe you can tell us, the general public, why wouldn't this body allow the House to choose its own prosecutors? Why limit us to only one? Why give this governor flexibility to have a team, yet not the House? Is there something that we're afraid of? In the same letter that Representative Karina declined to participate as a singular prosecutor, she asked the Senate President to reconsider again the House to reconsider the House's request to allow
Representative
for a team of
Staffler,
prosecutors.
if I may ask, do you stick to the order of business? I think you're bordering talking about the rules again. So
Okay.
that thing has come and gone, respectfully.
Thank you. I want to humbly thank Senator Santos, Senator Hokuk, and Senator Manglona for advocating that we be allowed to be the prosecutorial team to do the work that we've prepared to do. I'd like to thank you for advocating with the Senate President to reconsider. Now, I would like to also mention that, sorry, let me turn my letter around. Thank you for your patience. Well, I will just get to the point. Unlike Attorney Uggan's allegation that Rep. Tina has been planning for this impeachment since the investigation began years ago, I and many voters can see that she has been following this governor's long-standing patterns of misuse and abuse of government funds. What I and the House impeachment team would like to make abundantly clear is that this governor's actions are not mistakes. They are all patterns in supporting his enrichment of himself personally from his position as governor. He has carelessly wasted hundreds of hours of government time and estimated $500,000 or more of government resources, yes, taxpayer dollars, on lavish meals with his family, first-class travel with questionable public purpose justifications with his wife on more than 50 occasions, thousands and thousands of gallons of fuel fishing around and touring the Marianas waters, and thousands of dollars of reimbursements for electronics claimed for office use, but is nowhere to be found in the government inventory. We have the documentation to prove it. If you had only given the House clerk the extension she had requested to address the issues found on this impeachment record. The technicalities found in the record that were dismissed do not erase the data that they hold. The technicalities, again, I say, the technicalities found in this record do not erase the data that they hold. Thousands of pages of receipts of reimbursements and hundreds of TAs processed for per diems and amendments after the fact. Definitely glaring a lack of trip reports.
Dispensa, no, Representative Staffler, I was just giving the cue that you've already exhausted your time. So I'll give you one more minute to.
Thank you, sir. I will close. While it is true that it is the Senate's duty to conduct the impeachment trial, it is also true that it is the House's duty to safeguard the public purse. And when a public official, no matter who it is, repeatedly violates the law, only the House has the authority and a responsibility to impeach that public official to strike them down. This governor should not and cannot be allowed to use this honorable Senate body carelessly and recklessly to protect himself when it is clear what he was doing was wrong. This governor failed to follow the laws of the Commonwealth, and well before these Senate rules on the impeachment were ever drafted. And to quote Attorney Uggan, I humbly ask this honorable body to do what's right and just send a clear message to our people that no person is above the law. Thank you.